Okay, once again, welcome everybody on this session, International Webinar of Free Speech, Democracy and Rights of Minorities. This session will be focused on the issue of legal cultures on the free speech on internet. And however, we start from the introduction of director of Human Rights Center in the University of Madrid. Carmen, the floor is yours.
Thank you very much. Okay, first of all, I want to thank Professor Oscar Pérez, organizer of the event, for giving me the opportunity to address these few words of welcome. For the Human Rights Institute, Gregorio Peces-Barba, it is an honor to receive you today in this webinar, in which a topic of such relevance to democracy and freedom of expression will be discussed. Specifically, in Spain, one of the latest judicial decisions on limits, which seem to handle different parameters when it comes to protecting the established order and when it comes to putting limits to intolerant speeches, as well as the regrettable reaction from the extreme right to the rebound in homophobic episodes, are examples that the issue is not resolved. During the three sessions, we will reflect on legal cultures and free speech on internet, democracy, free speech and misinformation, and free speech and minorities, hand to hand with relevant researchers in the field, following a path already started last year with the webinar International Struggle for Recognition. With the international webinar, Struggle for Recognition, Cultural Pluralism and Rights of Minorities. Thank you also very much to the speakers and participants, specifically those of today, Professor Skrzypczak and Tsesis. I'm sorry because I mispronunciation. No, and have a nice word.
Excellent. Thank you very much for such warm words and for opening this webinar. As I understand, this is a series of 3 seminars in July. First of all, I would like to thank Oscar Pérez de la Fuente for organizing this, this event and for hosting our in not Madrid, however, in the digital space. However, it seems that this is very interesting that now in Poland we have 6 p.m. and in Chicago it's midday, yeah? Alexander, I guess that okay. In fact, we have 3 presentations during this session. First, Human Dignity and Free Speech by Alexander Tsesis from Loyola University, Chicago. Second will be, I guess, Oscar. Yes, you will be second, okay? And free speech and internet from the Chinese and Russian perspective. I guess it. I know because I've got this presentation, in fact, Ariel. So it will be very interesting presentation. And finally, I'm sorry, it will be my presentation about SLAPP. Strategic lawsuits against public participation and analyze between the right to a fair trial and the chilling effect for freedom of expression. Yeah. So let's jump to the Chicago. Alexander, I guess that you are in Chicago, yeah? In fact,
I am really much north of Chicago.
Okay.
But in almost in Wisconsin, but Loyola University is in Chicago. Yeah, and I'll be actually traveling to Washington D.C. next year to work at George Washington University for a year. So
excellent, excellent. Human rights and human dignity, sorry, and free speech. Alexander, the floor is yours. Okay, we have 15, 20 minutes for each presentation. Yeah, Oscar.
Yeah,
all right. Yeah. Okay. Oh, maybe more. If you
well, I'll do my best to keep it within the limit. So I have begun a project that in some ways is very far along, and in other ways is very difficult to get off the ground. It's based on concepts about human dignity and issues of incitement that have appeared in my works for many years, but I see something quite new which involves the same concern for individuality, for liberty, for free speech, free expression, but at the same time requires some reconsideration of restrictions that can be placed on insurrectionary speech, or not only just what we have been talking about for so many years, which is hateful speech when it is intended to harm a particular group, whether through discrimination or through violence. But now, in the age of Donald Trump, and the extent to which the United States Supreme Court has limited the ability to place restrictions on expression, to consider what can be done in light of the very, very strong protections on free speech in the United States. And then the project will certainly compare, and needs to compare quite a bit, dealing with European law. So the very simple way of putting this project is one that considers how dignity, democracy, free speech can be continue to be of utmost importance, and to place adequate barriers against autocratic violations of those principles, dignity and free speech, while at the same time not allowing democracies to fall to the sort of populism that we've seen in Poland with Duda, and of course with Orbán in Hungary, and I mean, not to mention Joseph Kabila in the Democratic Republic of the Congo, and all the pretend democracies that use restrictions on speech to further stifle dissent. And so it's this balance that I've been quite for a long time working out. The work that I intend, and or let me, before I go into the real details of it, let me explain what I would love to hear in comments and questions and answers, is how to improve this central feature of the paper, which is what restrictions can be placed on speech, what balance can be made, and is it possible, is it reasonable to even consider such things without harming democracy and without allowing for autocratic repression of speech. So, and I will flag that part of the work once I get there and say, here's what I've got, and what do you think, and can you help me advance it? That just to sort of expect that. But I'll give you the whole background of the project first, and then tell you where I'm at with trying to find a solution and ask for your help with it. So there's a doctrine that certainly David knows on this call, and probably everybody does, which is the Brandenburg test that derives from a case in the United States that found that limited the ability to restrict incitement. This was a Ku Klux Klan case. It was a case where it was a private group that was burning a cross, and this private group went on its own individual land, and there was an arrest because of the hateful, demeaning statements that were made against Jews and against blacks. And the court found that an Ohio statute was unconstitutional because it went too far in restricting speech, and it created the current U.S. test for the First Amendment, you would say. This test is one that allows any sort of advocacy, unless it's directed at inciting or producing imminent lawless action, and it is likely to incite and produce such action. Now, I suppose if there were something that my paper concentrates on, or I can even say much more directly, of these elements, my paper concentrates on imminence, but it also considers intent. Now, intent is not mentioned in Brandenburg versus Ohio, but a couple of years after the decision of Brandenburg, which was 1969, so around 71, maybe 73, the court finds that intent is also a necessary element. It's implied already in Brandenburg, and it's made more clear. So there's a scienter element, and I want to talk about that in this paper as I mold it, but also the imminence component, which of course is central to the Brandenburg test, and those of you who know this test will easily recognize. So the very critical thing for me in this paper will be to come up with a feasible alternative that will both keep the most important parts of Brandenburg, being the protection against suppression of expression, while at the same time seeing if I can come up with an alternative test that would allow for government to step in if there were an attempt to overturn democracy, as Donald Trump tried to do. And so I think, those who argue that the U.S. is completely safe against its representative principles, that is to say, where people can speak their mind about core political ideas and core ideological ideas, the idea that the U.S. will never, can never be broken, and that it's a democracy that can never be broken, I think at least has to be put in doubt after what Donald Trump was able to do in moving his base in attacking the Capitol on January 6th. And in reformulating this test from Brandenburg, no doubt this has to be considered and resolved. This balance that I spoke about has to both protect core speech, and by that I mean political speech. By core speech, I mean political speech, philosophical speech, scientific speech, aesthetic speech, and historical statements. Those seem to be completely at the core of democracy, where no viewpoint discrimination can be countenanced except in some sort of almost impossible scenario. I'm sure I could come up with something, but I can come up with unrealistic scenarios. Political, philosophical, scientific, aesthetic, and historical statements certainly would be conclusively protected in the United States, but I believe that their protection can only be in those extreme circumstances prohibited, and one can really, it's almost impossible, as I say, to come up with such a source. So incitement is a separate category, and it certainly is under the United States Supreme Court law, and it is typically thought of as a low-value category. That is to say, it is beyond the parameters of what the First Amendment of the United States covers, and of course the Free Speech Clause is part of that First Amendment, and therefore it's just thought to be external. Incitement is thought to be completely external to the range of what the First Amendment could possibly cover. But I think it takes more than that to really consider what should and could be possible in preventing democracy from falling from these autocratic forces that I may say, and this is my first entry into this, but I want to speak further into it, about restraints on, typically the conversation is about restraints on discriminatory statements. I want to take it further with this paper, and what I think makes it more complex, at least for me, is how to prevent not only incitement, but incitement that could lead to insurrection. Why is that so important? Why at such a time? Well, as you recall, Donald Trump's second impeachment, the articles of impeachment that came out of the House were accused him or indicted him for incitement to insurrection. And so that's really the core of this project. I think it's quite timely. It differs from what was done in the Senate and the House of Representatives. The Senate with the trial following the trial for impeachment in the House, because there were not criminal charges there. And I'm looking at, can criminal charges still be brought, not only against Donald Trump, but someone like Trump, who tries to exploit democracy in order to harm democracy, the way it happened in Algiers and the way that certainly in the Weimar Republic, but one could argue again in certain modern day countries, you could go just as well, the one I mentioned before, but also Zimbabwe or Tanzania, where the organs of so-called democracy, the so-called rights of free speech, are used to suppress individuals' views. I think as far as coming up with a solution, my idea is to have a statute that would both distinguish between the private and the public realms, as well as come up with an adequately rigorous test that would begin with the Brandenburg incitement test that I told you about earlier, but it would also it would also differ from it insofar as it would have a distinct strict scrutiny test. That is to say, the government could only prohibit certain statements if it had a compelling government interest and the law were narrowly tailored. And to have that to be a continuation, to continue as the test in private settings, and also particularly where political, philosophical, scientific, aesthetic, and historical statements were involved. But in the public realm, where there is a true incitement, to modify that imminence component to something like substantial threat of harm and a likelihood of harm, or significantly realistic harm, right? These are the sorts of tests that I'm thinking of without having come up with what the actual tests should be. And I do think that there should be retention of the imminence component. And I'm not the imminence, I'm sorry. The imminence component is the one where I would modify it. I meant to say the intentional component I do think should stay there. I do think it should be clarified that the scienter of the defendant should, if in the reformulated Brandenburg test, should not only just be purpose, but could also be knowledge or recklessness. This would make it easier to prove up a case of incitement, especially incitement for insurrection, but it would not be something that would be so lax that an autocrat could come in and say he's protecting democracy by suppressing a political party or suppressing an individual from speaking. I'm curious what you'll think of that. My project, by the way, is not the project of militant democracy. This is a line of thought that many of you might know that comes from Lowenstein in the 1930s, who came up with this concept in order to prevent groups like the Nazis from entering into politics. At least in the US side, I don't think militant democracy is feasible because of the right to association and because of the right to have abstract views, even abstract views that border on fascism or even are fascistic, even support for terrorist organizations or even communist. I think where the distinction between militant democracy is in my project is my project has an intent component and has an intent component of what I think a demagogue like Donald Trump wanted to do, which is in fact to create an insurrection against his government. So now let me, I know that I'm at 15 minutes. I'm going to take my entire 20 minutes. I want to talk more now. I want to change gears a little bit, but this will also be a very important component for the paper, is that in finding a solution for the current status in the United States of these very, very absolutist views on the First Amendment, I think it's critical to look to European law. And so once the paper is written, it'll have a large comparative component, or I shouldn't say large. It's not going to be over 50%, but it'll be a substantial discussion of comparative law. As you know, overseas, and this will come as no surprise to those of you who are there is a much greater permission in the law. The law countenances to far greater extent limitations on speech when they come to prohibitions against statements that are racial slurs, that are anti-Semitic, that are homophobic, that are sexist, and the like. I think that while few have ever talked about this, although there is some intimation of this in the literature, that the sorts of stereotypes that the Europeans seek to prohibit through their laws, while those would never work in the United States, if we think of them as anti-discrimination law, that is to say, what we in the United States would generally think of as employment discrimination law, these are anti-discrimination laws that in Europe are taken out of the limited context in which they are allowed in the United States, right? Sexual harassment speech is not permitted in the United States in the workplace because it is the workplace with 15 or more employers, as the statute Title VII of the Civil Rights Act of 1964 is written, is one that requires a substantial impact on the economy, the national economy. Doesn't exist in European law. So there is some distinction, but it's not as entirely separate from the U.S. considerations of civility as is typically made out to be, which puts a much more hard line or wall of separation between the way the U.S. and Europe handles it. Obviously, the extent to which minorities are covered, even on the internet, are far greater, or I should say, I apologize, let me say that in a different way. The way that discriminatory statements against minorities are covered in, let's say, Germany is far more than anything you could get in the United States. So most recently, the Netz GD statute that was passed that requires internet services to take down various internet statements that and as you say, they have to be taken down within 24 hours that make statements against particular identifiable groups in the statute is one that wouldn't pass in the United States, but it's one that is used to a very limited extent. So typically there's a big outcry in the United States against hate speech statutes. But when we really see the way that they're used in Germany and elsewhere, it's certainly much more limited than one would expect. In other words, not only Germany, but Spain as well, which is very careful not to restrict the point where democratic speech is prohibited. So there have been convictions for things that I do think go too far, where they could harm democracy. For example, there was a case out of Spain that Oscar would know better than me, with Jose Miguel Arenas, that prohibited, where he was convicted of prohibiting exalting terrorism and humiliating his his victim, that I think would be much more than the incitement to harm that I'm seeking to restrict, and would not work under the First Amendment in the United States, because in Europe, the allowance of protection of dignity and democratic norms goes as far as fear and anxiety, which clearly are prohibited. The government would clearly not be allowed to restrict things that are emotional, and this we know from cases like RAV versus St. Paul in the United States. So I want to be able to learn from Europe, but now in this last half a minute that I have, let me clearly flag what I would love to have you help me. I have found quite a bit of literature in the European scholarship with militant democracy, and with these statutes that I only had time to really skim the surface of, and we'll do much more in the paper, which is these statutes against hate speech in Europe that have intent components, where democracies prohibit intent and intentional hatred against identifiable group. What I would like to know is if people could help me advance the research to European statutes that specifically prohibit incitement against democracy, specifically prohibit incitement against insurrection. And I know that those exist, for example, I believe in Denmark, and I assume elsewhere, but I look forward to learning from you. Thank you.
Thank you. Thank you. Thank you very much, Alexander, for a very interesting presentation and analysis of human dignity and free speech. Oscar, I guess that discussion will be on the end of the session, yeah?
Yeah, I think it's better at the end.
Okay. Okay,
yeah,
great.
Yeah.
So, I think that this is a time for your presentation, okay? So,
Okay.
The floor is yours. Free speech and the internet in this new interpretation for human rights, with a special reference to Chinese and Russian approaches of internet regulations. Oscar, the floor is yours.
Okay, I think, well, first I am very pleased to be here today with these two colleagues join this session, and also I am very glad to organize with these two colleagues all these sessions of this webinar, international webinar, and I hope this will be an excellent opportunity, an excellent initiative to join energies and to join efforts in order to quality in academy and quality in research, and also a good discussion. I think it's quite very interesting to speak after Alexander Tsesis and this paper and this intervention, because I am going to talk about the other side. His paper is about insurrection and free speech in the American approach and in the European approach. I am going to talk about what are the limits of political speech in Russia and China. And I think this is a very current affair, and this is could be quite interesting, especially on the internet, free speech on the internet in China and Russia. The first thing that I have to say is that there are a few sources, a few academic sources, and there are some articles, some books, but it's not so there are not a lot of sources that you could imagine. There are few sources and few information about this topic. Okay, I would like to begin with the classification of polyarchies and hegemonies from Robert Dahl, that it's an important scholar who classified democracies. He said that democracy is very idealistic, and he says that actually we have polyarchies, and he distinguished polyarchies from hegemonies. In the polyarchies, we have some legal rights recognized and also applied, no? As, freedom of expression, right to vote, equality for public office, right to political leaders to compete for support, right of political leaders to compete for votes, alternative sources of information, free and fair elections, institutions for making government policies depend on votes, and other expressions of preferences. Okay, there are two variables in order to classify the different regimes. Liberalization, this means this is a variable between liberty and authority. And participation and inclusiveness is the degree of democratization of different societies. And according to Dahl, we have closet hegemonies without liberalization and without inclusiveness, no democracy, no liberties, and polyarchies, liberties and democracy. And we have mixed regimes, competitive oligarchies, and inclusive hegemonies that have some of these characteristics, but not all. I think this is a good introduction in order to explain what is the situation in China and Russia from the free speech and political speech approach. Okay, the doctrine have said that in China, the internet in China is a digital opium, an echo chamber, an online vigilantism, online link mobs, digital charter letter, digital Maoism, cyber ghettos. Okay, I think we cannot simplify the view. It's true that the Chinese government monitor and control and censor certain views, especially the views against the government, especially the dissenters' speech. However, there is deliberation, there is popular channels to express themselves on the net, and it's not a question of black and white, it's a question of grace, I think. The doctrine, for example, has said that there is a networked authoritarianism on authoritarian deliberation. The first idea is there is no competitive elections, competitive and pluralistic elections. This is there is only one party, is a one-party system, China. However, there is deliberation, there is online deliberation, and for example, there is some doctrine that said that this is linked with the Confucian culture in China, and is the population have different channels to express themselves. However, it's true that there are breaches of human rights from the citizens, from the governments. There is censorship, there is government control, the government monitor of the speech, especially the political speech. And of course, there is no possibility to organize an opposition movement. Okay, especially this author, they have several works about explaining the particularities of the authoritarian deliberation and the cultural particularities of this authoritarian deliberation. That says that, okay, maybe it's the seed, maybe is is a good point in order to, in the future, initiate a democratization process. But of course, authoritarian deliberation is something self-contradictory and is not democratic, and but is something good because there is deliberation. Of course, there is great censorship in China, especially with electronic means, and all the protesters and dissenters are censored by the government by different means. For example, the first generation controls what is called the Great Firewall, China's Great Firewall. It's a electronic blocking of different websites or the second generation control that involves considering crimes certain activities is a legal and technical framework in order to persecute certain conduct as considered crimes. Or for example, the third generation control, that it's a propaganda strategy against those who are against the system, the Chinese political system. There are another electronic state intervention as cyber attacks, device and network controls, domain name controls, and localized and disconnection and restriction. The surveillance of the Chinese government could be with a classic monitoring, for example, with anti-terrorism measures, or with law enforcing compliance, considering crimes, certain conduct, certain activities. This law enforcement compliance is very interesting for the legal point of view because it's linked with the Russian approach, and also it's not exactly linked, but it's the problem of persecute political speech, insurrectional political speech. What is the degree of the persecution of the insurrectional political speech in an autocracy, in an hegemony, not in a democracy? Okay, the astroturfing and public outreach is another technique of the Chinese government. The astroturfing is like a propaganda technique. It means that he uses certain campaigns that it seems to be popular and it seems to be spontaneous. However, these campaigns are intended and are directed by the government. And it's another way to control the net by the Chinese government. Finally, the conclusion from China. The criticism of Orientalism. Maybe my approach is from the sources, certain sources from the Western sources or certain sources for Chinese sources. The idea is that we can see China as the other, and we can see that China has problems with internet. And we can see that situation could be improved in several ways. Okay, Russia, the Russia situation is a bit different, in part because Russia is part of the Council of Europe, and there are several rulings of the Council of Europe against Russia for the breaches of human rights. There are, for example, the case Pussy Riot. It's a case of a certain desecration, a certain blasphemous activity. Is a right to protest of a punk group in the Cathedral of Moscow that was considered by the European Court of Human Rights a political right to protest against Putin government. And according to the Russian authorities, according to the Russian court, was considered a blasphemy, or was considered a crime. The second case is the murder of Anna Polyotskaya, that it was a journalist assassinated, and this journalist has denounced the political situation in Russia. We have in Russia a situation of intimidation. Maybe it's not a clear censorship, so clear that as China, is more a situation of self-censorship or certain situations of harassment. But in Russia, what is important is the anti-extremism legislation. There is a great extent of the hate speech, for example, legislation that includes separatism, terrorism, or it includes certain concepts that are vague and ambiguous. For example, in 2012, there was a censorship law against extremism web content, and the Pussy Riot video was censored by the government with this legislation. There is a crime that is vague, and I think this crime is so vague that it's called incitement to extremism. Or, for example, the social hatred or the propaganda of social, racial, national, religious, or linguistic superiority. Or the public calls for extremism. Okay, the problems with hate speech, with opinion crimes, is that if they are not strictly characterized, it's a problem of judicial interpretation. And the judge, for example, in Spain, the judge are reluctant to punish for the hate, for incitement to hate, for the crime that is called incitement to hate, because they consider that opinion crimes should not be punished, are legal conceptualized, but should not be punished. My opinion is that incitement to hate, referring to minorities, to what is usually understood as minorities, should be punished, but not hate speech in order to other situations or in order to other collectives. We can talk in the debate after about this. There is another control of websites by the Russian government. And finally, Russia has proposed in 2011 to the United Nations to a code of conduct of international security in order to internationally persecute the dissemination of information that incites terrorism, secessionism, or extremism that undermines other countries' political, economic, and social stability, as well as their spiritual and cultural environment. Of course, I think this proposal is linked with Alexander Tsesis' presentation in a certain way. It's not the same Russia and China that United States or Europe, but the problem is the incitement to extremism or the incitement to secessionism. This could be persecuted in a democracy in the same way that in an hegemony. Okay, conclusions. From the point of view of liberalization, either China or Russia, they have some degree of liberalization, but they are not. There is no real public contestation. And about inclusiveness or participation, they don't have real participation. And Russia is under the European Convention of Human Rights. My final thesis from this ongoing investigation of the situation of China and Russia on free speech and internet is China is an hegemony, and Russia, we could say that is a mixed regime, has certain characteristics, is more subtle, but it's not a polyarchy. It's not a clear polyarchy. Thank you very much.
Thank you very much, Oscar, for this presentation. It was a very interesting comparison Russian and Chinese circumstances of internet and human rights, of course. Okay, ask Oscar to be a chair during my presentation because you know limit of time. It's sometimes this is a problem for me during the presentation. So I will be grateful for sharing this during my speech. Okay.
Okay, yeah.
Okay. Yeah.
I put the slides. Do you want to see the slides? Or
Yes. Okay. Maybe it will be possible when I
yeah,
switch. Okay.
now.
Yeah.
Okay.
Okay. So at the beginning, okay, maybe at the beginning, I would like to thank for Oscar for once again for organize this meeting and for possibilities to share with my ideas during this session. So maybe at the start it is necessary to decode the abbreviation used in this title of my presentation, SLAPP. It means, of course, strategic lawsuit against the public participation. This is considered a form of legal harassment. It consists in undertaking deliberate legal action, i.e. Bringing lawsuits, private indictments, or notifying law enforcement agencies by law firms, law companies representing very important persons, influential persons, organization, or sometimes state institution, in order to exhaust financially and mentally with a view to suppress critical voices and opinions to the detriment of public participation and to avoid public scrutiny of person acting to protect the public interest. So we can say that strategic lawsuit against public participation, this is a form of retaliatory lawsuits intended to deter freedom of expression on matters of public interest. SLAPP definition was proposed by George Pring in 1989. The author defined this abbreviation, the expression, as any type of legal action, such as lawsuits, indictments prepared by influential entities, e.g. corporation, public officials, high-profile businessmen, against journalists, human rights defenders, academics, also civil society organization who expressed a critical position on a significant issue of political or social importance. One of the main characteristics of this type of action is the disproportion, and maybe this is a key word, disproportion of resources between plaintiffs, usually huge private or public institution, and on the other hand, defendants, journalists, whistleblowers, etc. As has been emphasized in public debate, the aim of SLAPP suits is not to genuinely assert a right. SLAPP suits are often based on meritless, frivolous, or exaggerated claims and are deliberately initiated with the intent to intimidate, drain the financial and psychological resources of their targets, rather than generally exercise or vindicate a right or obtain a redress for a certain wrong. The action discussed here are based on the resources depletion and the strategy of affecting the morale of the defendant. Often such lawsuits have little chance of success. This is interesting. But the point is to stay in the court dispute as long as it is possible. Plaintiffs usually know from the outset that their allegations are unfounded or exaggerated. But they also know that being a defendant and facing an investigation and possible trial is both costly and, what is also interesting for such person, time-consuming. As a consequence, harassing lawsuits can have a strong chilling effect. preventing a journalist or activist from re-exercising his/her right to criticize. And even when the court dismissed this claim, the length of the trials and the threat of damage or penalties frequently leads to a chilling effect. Mentioned chilling effect. These goals are attempted by making exorbitant claims for compensation or allegation designed to slander, harass, and overwhelm activists and or civil society organization. This is a deliberate action that is expected to lead to a chilling effect mentioned here. The effectiveness of such strategies depends on various factors, of course, including the amount of the cost of such trials, legal cost of legal representations, provisions of infringement of personal rights and defamation, and the existence of safeguards like, for example, anti-SLAPP law or awarding costs against abuse of law. So, SLAPP in practice, okay. According to the European Commission analysis recent report, SLAPP suits are increasingly conducted across EU member states, unfortunately, in an environment that is getting more and more hostile towards journalists, human rights defenders, and various NGOs. In Europe, according to this data, for every European journalist or activist who is threatened with violence, there are 100 more persons silenced by law companies, law firms. Many examples of this type of legal action can be found in European countries, like, for example, in Spain. For example, case of company in France, Bulgaria, Romania, Portugal, Slovenia, Croatia, Germany, Italy, Norway, UK, and of course, unfortunately, in Poland. According to the last report of Polish Journalist Society, there are currently, we can find almost okay, let's go to the next slide, okay? May I ask you? Okay, yeah. We can find almost 200 such cases which can be classified as harassing journalists and the media. There are cases of both civil claims for damages, case for rectification, but also criminal proceeding. This is famous in Poland and also in Europe, Article 212 of Penal Code, Criminal Code, or other cases, for example, detention or attempts to waive journalistic secrecy, as well as proceeding initiated by journalists in the field of law, work of response to dismissal or discrimination of political grounds. So, according to these studies, the most common entities that legally harass the media and journalists are public institutions, like, for example, ministers. This is almost about 30 cases, politicians, 26 cases, the public prosecutor's office, 15 such cases, persons associated with politicians, 15, judges, next 15 cases, state-owned companies. What is interesting, even TVP, what is it, TVP? This is a public television, public TV station. In fact, this government TV station. I'm afraid that this is not a public, in fact. Prosecutor 3 and ruling party 3. What is also interesting, the most often attacked media are Gazeta Wyborcza. This is the second biggest daily newspaper in Poland and maybe the most opinion daily newspaper. More than 60 cases. RISP, this is Rainer Axel Springer, Swiss-German company in Poland. more than 40 cases. Okopress, this is independent portal, internet portal, 8 cases. Politica, this is a weekly, opinion weekly, very popular in Poland, 9 cases. And TVN, this is a private television, so with American capital, 4 cases. So let's jump to the next slide about anti-SLAWP law. Recently, there are many examples of, not maybe many, some examples of the adoption of anti-SLAPP law regulation, which generally speaking are aimed at more reliable safeguards for the defendants in this type of trial. Anti-SLAWP laws are more developed in the United States, Canada, and Australia, while in Europe, anti-SLAWP regulation are rather unknown. According to some researchers, this situation results from different consideration of the right to freedom of expression in the constitutional systems of these countries. While freedom of speech is protected as an almost absolute right by the US First Amendment, the necessary balance between this fundamental right and other interests, such as reputation rights, is ensured in European national and regional system. For example, Article 10, paragraph 2 of European Convention on Human Rights. So please, next slide. Anti-SLAWP regulation in US, the Congress never passed federal anti-SLAWP law. However, there are some anti-SLAWP laws in particular states. Generally, idea of such anti-SLAPP regulation provides that the court looks at the lawsuits at the very preliminary stage and decided whether it is a question of public affairs or a voice in the public debate or not. If not, the court dismisses this case. We can find some examples. However, I'm afraid that we don't have enough time to present all examples. In my paper will be more about this. However, good example is Washington regulation. So in May 2021, Washington enacted a version of the Uniform Public Expression Protection Act, a model anti-SLAWP law developed by the Uniform Law Commission that was enacted in several state legislatures. The new anti-SLAWP protection applies to claims based on an individual's exercise of the rights of expression, freedom of the press, ensemble, petition, and association on matters of public interest. Thus, it essentially enables defendants to bring application for a summary judgment at a much earlier stage in the proceeding rather than after a long and costly period of discovery. Okay, and anti-SLAPP in Europe, it will be on the next slide, please. Slide number 8. Okay. It is believed that anti-SLAWP regulation can also be based on international or regional principles that protect freedom of expression. For example, Article 19 of International Covenant on Civil and Political Rights, and especially Article 10 of European Convention on Human Rights. In the case of the last article, I mean about this European Convention, the guidelines of the European Court of Human Rights may also be helpful, which in the case of Handyside versus Great Britain, and court stated in this case that a democratic society should also tolerate those ideas which offend, shock, or disturb the state or any sector of the population. Another key case was Steele Morris versus UK from 2005, in which the European Court of Human Rights found a violation of Article 10 of the Convention. Interesting. This is this case. The applicants, namely two members of London Greenpeace, were asked to reimburse 40,000 euro for damaging McDonald's reputation through a brochure entitled "What's Wrong with McDonald's?" According to the court, the violation resulted from the state inability to provide legal aid to activists who were persons with very low incomes toward one of the richest companies in the world, and from the size of ruling given to them. However, currently, no EU member state has introduced target legislation that specifically protects against SLAWP lawsuits. In February 2018, a group of European MEPs called on the European Commission to prepare an EU anti-SLAWP directive that would give investigative journalists and media groups the right to demand that troublesome lawsuits be dismissed quickly and create a fund to support media groups resisting such trials. Moreover, MEPs also proposed the creation of this is very interesting, new EU register that would name this and shame companies practicing SLAWP. Suits. One of the reasons that prompted MEPs to promote such regulation is the case of very famous case, unfortunately very bad case, Daphne Caruana Galizia, a Maltese investigative journalist who was murdered in a bombing in October 2019. At the time of her assassination, he was sued by Pilatus Bank, a Maltese financial institution that she often criticized. Following this case, Malta decriminalized defamation. However, anti-SLAPP amendments were not taken into account. In November 2020, the coalition of non-governmental organizations from across Europe, like Article 19, Association of European Journalists, and many others, has appealed to EU, to policymakers in Europe to protect public watchdogs, such as journalists, rights defenders, activists, and whistleblowers from strategic lawsuits against public participation. Please, next slide, okay? Because, we must remember about other important rules, the right to fair trial. And according to Article 6 of the European Convention on Human Rights, everyone is entitled to a fair and public hearing with a reasonable time by an independent and impartial tribunal established by law. The conflict of rules of law, rights to fair trial, and freedom of expression is possible in this case, on this field. The best example of this challenge are the decision, for example, the best example that such conflicts could be possible we can find in some decision of US courts. For example, Washington passed, I mentioned about this, the new bill. However, first such anti-SLAWP law was introduced in 2010, but the state Supreme Court rejected it in 2015, stating that it violated the state's constitutional right to a jury trial, empowering judges to rule on facts before trial. So, time for conclusion, okay? It will be the last slide and my last, 2 minutes maybe. Legal actions of the SLAWP type are methods of silent criticism, far less, of course, barbaric than a car bomb or a headshot. but their chilling effects are often just as destructive. This is, of course, not the new problem. However, the SLAPP, SLAPP, it seems it is a growing acute problem today, and therefore a legislative response is, in my opinion, needed. It seems that, for example, European Union should adopt laws that will protect European citizens across the EU from such kind of legal attacks. However, we should always look for balance between two constitutional and conventional rules: right to fair trial and right to court, of course, and freedom of expression. Maybe the good solution, maybe the best, is looking for balance between those principles. Are the legal rules should be introduced that will allow the rejection of SLAPP cases at the very beginning stage of the legal procedure, but also impose sanction on SLAPP users for abusing the law and court proceedings, and provide the victims of these attacks with tools of defense. Given the importance of the role of social oversight bodies, such as investigative journalists, activists, and whistleblowers for the rule of law and the fight against corruption, when their security is not ensured, they endanger not only freedom of expression, but also the proper functioning of the democracy. The legislative intervention must be formulated in a manner which empowers national courts to attain the intended outcome of expeditious dismissal of cases without harming potential claimant legitimate rights to access court. Properly framed anti-SLAPP legislation affords the claimant the opportunity to present legitimate claims to the court and therefore satisfies the requirements of Article 6 European Convention on Human Rights. In addition to the adoption of an anti-SLAPP, for example, directive in EU, it is recommended also by these bodies that the Brussels 1A regulation concerning jurisdiction, recognition, and enforcement of judgments be recast with a view to adopting a specific rule concerning defamation claims, and thereby to distinguish jurisdiction in defamation case from ordinary torts. It is recommended that jurisdiction should be grounded in the forum of the defendant domicile, unless the parties agree otherwise. This would enable public interest speakers to foresee where they will be expended to defend themselves and be keeping with the core values of the Brussels 1 regulation. Of course, it depends, of course, of domestic case and regulation. However, I think that also it is important that in the case, in the Swedes, in case of mayor of city, politicians, etc. So it should be his own, her own legal action, not the office action. However, it depends, of course, on domestic regulation. So once again, we can say that this legal action, strategic lawsuits against public participation, of course, once again, this is far less barbaric than headshot. However, sometimes it's more effectiveness and in achievement the chilling effects. So maybe this is a time for reaction. And I know that such discussion in EU we can observe. Thank you very much, and I'm sorry because I broken my limit of time. Thank you very much.
Okay. Then I think now is the time for the discussion.
Okay.
I will ask some questions to both participants, both speakers, and then you reply, and then we ask to the public in order to ask questions if someone in the audience wants to ask some questions, and there is a final round, and we close the session.
Okay.
Oscar, until what time are we going? What time is our session concluding?
I don't know. We try to conclude maybe in well, I don't know, in 10 minutes, in 20 minutes, 20 minutes. Or well, yes, there is 20 minutes for debate. Okay, then the first speaker has been Alexander Tsesis. Very interesting paper. I would like to ask three points. The first one is what happens if the call for insurrection is done by the president? This is different. The situation if the protagonist of the call for insurrection is the president. The second is what happens if the body who prohibits the insurrectional speech is a private company as like Twitter. The president's speech, the insurrectional president's speech, if we consider that it's insurrectional, has been prohibited not by a judge but by Twitter, but a private company. This is something surprising for the European view. And finally, a consideration about the question of the paradox of democracy. The paradox of democracy is, could democracy permit undemocratic speech? Could democracy permit speech against democracy? And the experience in the Spanish democracy is that our constitutional court has said that we are not a militant democracy. You could defend any idea, but you cannot use violent means. It was a discussion about the political parties who don't condemn terrorism, but this was an old-fashioned discussion. But nowadays, the discussion is about independentist actions. And what happens if what happens with explicitly unconstitutional acts, for example, to declare the independence or to vote an illegal referendum? No, this is for Alexander, and for Jedrzej, I would like to ask. Do you think this SLAPP lawsuits could be understood as in the main approach of anti-corruption laws for protecting whistleblowers? This is a part of the anti-corruption protection of whistleblowers, or is in another view? And what happens about the good image of the people? What happens about the good image? It's only a legal point. It's only a matter of lawsuits, or there is also a problem with ideas, a problem of good press, a problem of good image of different people. And the final question is, what about money? This is powerful companies that are against whistleblowers, are against the nonsense. Powerful and powerful companies against people with less economic power. There is a problem of money behind these SLAPPs. Okay, now is the time for Alexander. You have to upload your micro.
Yeah, there you go. Yeah, I was just trying to find that. Thank you. Oscar, you ask really profound questions, all very, very complicated questions that I think that I need to address in the paper, that I plan to address in the paper, but you just reinforce my decision. The president, the first question is whether my judgment changes if the president leads the insurrection, is a very important one because of the Office of Legal Counsel, which is the chief office that provides legal advice to the president, has said that the president cannot be sued while in office. This is something that in a very recent article by Emily Berman, she argues that the whole Office of Legal Counsel is geared to supporting decisions that are favorable to the executive. So this central view that the president cannot be sued is one that comes from a legal office that is part of the executive branch and inevitably will be more favorable to the president. I'm not going to tackle that really as a central feature of the paper, although undoubtedly it's one that I will mention. But I will mention it just to say that given this predominant point of view that the president cannot be charged while holding the office, that I'm trying to develop a cause of action that is either for when the president has already left office, and then whether it can be charged criminally for acts that were done while in office for which he or she could not be charged while in office, or for private persons who are substantially likely and intend to commit an insurrection who are not present in the office of president, which I suppose could be other politicians, but are more likely to be private organizations, the way that the Bahutu party achieved success in Rwanda, or the Nazi party achieved success as a private party before entering into political office in Germany and in Austria. As to private companies prohibiting speech, let's just say speech, so that it's, because if I say free speech, it's a very loaded term, and if I say hate speech, it's a very loaded term, so let's just say speech. Here we have Section 230 of the U.S. Communications Law, that Communications Act, that restricts private causes of action against private companies such as Facebook, Twitter, and Snapchat and others. So that limits the ability to bring cases against those private companies, except where there's a criminal violation. Certainly nothing that I'm dealing with these companies have never committed anything like incitement to insurrection, which I'm going to be dealing with in this paper. If there were such a case, I would think that there could be even greater restrictions, at least to the point where intermediate scrutiny and not strict scrutiny would apply in the U.S. and in the EU. There would be greater possibility of restrictions because commercial features of these platforms. I don't want to say any more on that because I'm already talking too much. But in the final, but you gave me such great questions. The final question about the paradox of democracy is one that Oscar, you so eloquently spoke about the dangers of abuse of institutions where government says we are trying to advance democracy, but in reality they are suppressing political parties. And of course, as you said, Spain is not a militant democracy, which is a very, very important point. And that's why I was asking, what is the literature, what are the statutes against incitement to insurrection? So not where there are just abstract political statements in favor of communism, in favor of the Nazi party, in favor of hatred based on political or ethnic affiliation, but what are the U.S., what are the European achievements or laws and the EU doctrine of where this abstraction of politics, abstraction of philosophy becomes true incitement that's actually actionable, even though it's in Kuwait. It's not actual preparation of let's gather the weapons, in which case the government clearly can act, but where the experience with the Nazis or the more recent examples showed that at some point it ceases to be words and in fact is inciting to action.
Thank you very much. Jedrzej, it's your turn.
Okay, yeah, thank you very much for your questions. Okay, I agree that idea of anti-SLAPP WP law is quite controversial because, okay, we can say that this is right to court, yeah, on the one side, and however, this legal action, strategic legal action, are against freedom of speech. And when we will analyze the regulation, for example, in some states in US, so we can find that in some cases there are only such solution for the case for the fields, for example, of part of limited area of freedom of speech. Yeah, so I can say that in fact, the key word here in this strategic lawsuits against of public participation is disproportion. Yeah. So when you ask about the money, okay, we can find in some domestic legal system solution which can help even now such for example journalists, etc. Yeah. However, you know, when you have for example, I know journalists from Gazeta Wyborcza who has 10 or maybe more such cases from ruling party, from ministers, from state owned companies, yeah. And if you know, if you think that of course if you discuss with your wife, okay, I have 10 such cases and €1 million in one every case, so it could be conduct to the chilling effect. Yeah. So I think that once again, looking for balance between right to fair trial and right to court, and on the other side, freedom of speech, freedom of expression. I know that this is very difficult to find such a balance. However, you know, this action started from this 80 NGOs from Europe. I guess that we'll see. We will have a special directive, anti-SLAPP directive in Europe or not. I think that if yes, it will be good base for domestic regulation, yeah, for national regulations, and I think that you know, the right to something, for example, right to court, also have some limits. Yeah. Of course, we can answer. Okay, finally, independent court will decide. Okay. However, when you once again, when you are journalist, such public activists, it could be work as a chilling effect. So once again, I think it's necessary to find the gold balance in these two rules.
Okay, now is the time of the audience, the time of the public. Is someone, please raise your hand. If someone wants to intervene, please raise your hand. And now is the time if someone wants to ask a question for the three speakers. Yes, David Hahn.
Yeah.
Well, thanks so much. These are all incredibly fascinating presentations. And I had just I guess a few sort of, a question for each of the speakers. And for Alex, I was wondering if, Alex, if you could maybe just talk a little bit about how your view of Brandenburg relates to kind of just the issue of evolving technology since Brandenburg was decided. Because, Brandenburg was a case that happened at a very different time in technological development, of course. And it's a time when the court's main concern was, rallies and speeches and physical speeches and those sorts of things. And so I guess one question is, do you think there is a fundamental flaw in the original balance of that case that was decided in a time before, the internet, before YouTube, before all these other things? Or is it something that's maybe changed? Is it that the balance has changed because now all of a sudden it's really easy for, certain speech to go out to millions of people instantaneously? That just wasn't physically possible back in, the 60s when Brandenburg was decided. So Alex, I was wondering if you could sort of share some thoughts on that. For Oscar, I thought it was fascinating, this idea of authoritarian deliberation, and I was actually wondering if there was a little more detail you can give of sort of what that looks like in China. It is kind of a strangely contradictory kind of idea, and so that to me was just an interesting thing. Another thing and I was curious as you if you came across this in sort of your research is, to what extent in China is there because I've heard, sort of anecdotally from people that there is a kind of de facto two-tiered system when it comes to, say, access to certain websites and things like that in China, where if you have the capability of VPNing out and you know how to do a VPN, you are kind of able to do that, at least in certain, I don't know if it's universally in China, but for some, there's a lot of sites that are blocked and things like that. But for others who have this sort of technological capability, it seems like I don't know if this has changed. I don't know if this is an old phenomenon, but it seemed like the government was a little more willing to kind of, let that go if people did have this sort of capacity to say, go around the firewall. And Jedrzej, it is fascinating to hear sort of the difference here, because as you noted, in the U.S. there's a strong anti-SLAPP legislation in many states. California, where I live, has very strong anti-SLAPP legislation. And one question I was curious about was, to what extent is this? I think, as you said, a lot of this difference is probably just a cultural difference in how the U.S. views freedom of speech. The U.S. is very, very freedom of speech focused as far as the balance goes. The U.S. tends to weigh very strongly on the side of freedom of speech as against other values. But I also wonder if there is an aspect of, are there differences? And this is something I just don't know the European court system very well. But is there a difference in the frequency, the likelihood, the practice of, say, motions to dismiss in the United States, procedure, that is just not as, say, it's not as frequent in Europe, where in the U.S., federal rules of civil procedure, for example, it's, you can get cases dismissed, but, without any discovery, without much, I would not say easily, but it's a pretty standard kind of device. And is there more of a reluctance to dismiss cases early on, generally in Europe, as opposed to the United States?
Okay, thank you.
If there is no,
should I go?
Is the time for Alexander?
Okay, I'll try to be very, very quick because so little amount of time. David, the question is really, really profound, important. It's one that you've written about, and I know Alan Chen as well, and I'll certainly use your work. I do think that Brandenburg stands on its own, even irrespective of technology. I've written about this before because Brandenburg occurs at a private location. There's nobody invited except one journalist and his cameraman. There is some technology involved, but ultimately there's no danger to either one of those two people who are present. That's different in Virginia v. Black, because there's a true threat against individuals who are not invited and who view from afar the burning cross. There's no technology there either, but the distinction is one that I think is important because one is occurring in a private place, one is occurring in a public place. British law, for example, distinguishes between free speech that's almost unlimited or unlimited as far as I can tell based on the statute and then the case law in private, and one that's in public, and that I think is because of the potential to incite. And I do think that translates to the internet, because if speech is done in a setting where it's intended to bring on a particular form of harm, of discrimination, disruption, violence, and particularly insurrection, it should be looked at in context and based on circumstances. So this goes beyond just the issue of technology and goes to one of balanced context. I want to make this law extremely difficult to apply because of the certain things that Oscar has spoken about with China and Russia and many other places, Turkey, Vietnam, obviously North Korea, where the internet is completely suppressed. And I, in that regard, to quickly stop here and to ask something of Oscar, and I know there's that Jędrzej has a question posed to him before Oscar, but maybe to follow up, Oscar, is there some point where you can say some sort of test to delimit the abuse of restrictions? Can we create a legal test, or is it one that's so unworkable that we cannot trust courts at all, and it's just dangerous to make any sort of suppression even? And if so, what do we do with insurrection? What do we do with people who actually do try to use the institutions of democracy, as the Nazis we know did, to abuse autocracies? Is there any limit that can be made, or is it such a harrowing and such a dangerous endeavor that the U.S. is really the best model? So let me stop there. And thank you very much, David, for your question.
Okay, I think it's my turn. Two interesting questions. The first one, the authoritarian deliberation. Yes, for me, it's also a mysterious and interesting topic. I am in an ongoing research about this. From the Chinese sources, they defend that there is a real deliberation. Also, within the Confucian culture, and there is a way of deliberating issues in the Chinese culture. However, in an authoritarian framework, one party policy, no fundamental rights recognized and protected, and is contradictory. The doctrine says is a possible future seat of democratization. I would like to go ahead in this study, but my question is also a question connected with the Alexander topic. Is the paradox of democracy? What is the difference between China and the democracies? Is a matter of degree, or it's a real different situation between a state who forbids and censor, control, monitor all the others. However, it has deliberation. For this reason, the restriction of political speech should be always strongly justified. Should be always something strongly justified. And about what you talk about the DPM and the technology who could be overcome, I don't have information, clear information about this. I only could add that the platforms like Twitter, Google, and Facebook accept to follow the Chinese government policies in China. They accept the policies of the Chinese government about censorship or about information, about data, about everything. Okay, I think now is the time for Jedrzej.
Yeah, thank you very much. However, maybe coming back to your question. Thank you, David, for a question. I'm trying to answer soon. However, so I think that Oscar, that the digital technologies give such authoritarian governments completely new possibilities. It seems that internet, this is a space of freedom, etc. However, in not only internet, however, also digital technologies can give such regime like in China or Russia many possibilities to surveillance people. And so I remember the opinion officer of Secret Service before collapse of communism in Poland. And he said, okay, if such tools or like digital technologies was invented during the communistic time, okay, this system never ended. Yeah, so I think that unfortunately this is right. Thank you very much, Alexander, for your opinion. However, I think also that okay, we discussed with Oscar lately about the so social media are the public sphere or private sphere, because this is a private companies. I mean about, for example, decision of Twitter of canceling the Trump account. Yeah, so this is a decision of private company, or this is decision against the freedom of speech. Yeah. Okay, David, thank you very much for the example of anti-SLAPP regulation in California, because I remember this is also a very interesting case. I think that what is interesting in the anti-SLAPP laws, that in fact this is because I mentioned that it could be a controversial regulations, okay? From this, for example, point of view, right to court, right to fair trial. However, yeah, this European attempt to this issue is a little bit different. I mentioned that maybe this is a result of way of thinking idea of freedom of speech in American doctrine and European doctrine. Okay, this is one point. Second is that in fact, anti-SLAPP laws, anti-SLAPP regulation, anti-SLAPP should give the opportunity to access to court. However, the main idea is, as you of course know, because you mentioned about this California regulation, that for example, this is a first phase decision of court, yeah, on the first side, okay, and in the result, the proceedings could be very short, However, in fact, it will be the decision of independent court judge. Yeah. So I think that of course we can find such regulation in other legal technologies. Yeah. For example, in procedure, civil or penal procedures. However. Now this is such a trend, like in some states, US and in US and even lately in Europe. So such regulation. Okay, thank you.
Okay, there is a quick word of Vladislav Siginenko, please.
Yes.
Yeah, maybe let me introduce Władysław Zinchenko. This is my PhD student from Ukraine. However, he is a member of PhD schools on Mickiewicz University in Poznan, Poland. Okay.
Thank you.
Władysław, welcome to you. Yeah.
Good evening, professors. First of all, let me thank you for these insightful presentations. I took really a lot from these 2 hours. And my question is to Professor Oscar Pérez de la Fuente. Professor, what is your opinion about Starlink technology as it is in development? Do you think it can potentially be counterpower to Chinese and Russian government? Do you think it can be a game changer for the free speech in the internet? Thank you.
I didn't understand the term. What kind of technology?
Starlink. This is a yeah.
This is a free internet which is proposed like to develop by Elon Musk, which can be like free internet and can be connected to yeah.
Yeah, I understand. Well, there are 2 approaches on internet. Free internet, in the sense that internet should be without any restrictions of any kind. And then we have the problems of WikiLeaks, or we have the problems of Hadopi, or the copyright laws. But there is an approach of internet that says internet without restrictions, and there is another approach on internet that is human rights human rights protected by internet, and it says hate speech should be not permitted on internet, or child pornography should not be permitted on internet. And there is a third level that is China and Russia that says political speech, dissenters should be not permitted on internet, monitoring and controlling and censorship the political opponents. I think completely free internet have problems, and I am in favor of human rights approach to internet. This means there are certain questions that should not be regulated on the internet, as I have talked, for example, hate speech, child pornography, or for example, copyright laws on internet. Okay, I think the chair is Jedrzej. If you want to say something at the end.
Yeah, idea of the free internet in Russia and China. This is a beautiful idea. However, I don't. Unfortunately, I'm rather pessimistic in this case. I don't know exactly the case of China. Maybe better, or because closer to me, is the case of Russia. However, Władysław is maybe has better better background, because he is from Ukraine. However, as I mentioned, this is an idea of free internet. This is a game of words in Poland, because in Poland, free, it also means slow. So we can say that, in fact, free internet, this is a slow internet, yeah, from technological point of view. I agree. With Oscar that I'm afraid that this digital technologies could be more offensive for citizens in the future, close future, than it was in analog time. It was a beautiful world when internet was academic space, yeah, non-profit space. Now governments and business went to internet, and I'm afraid that it will be rather new possibilities of censorship that new possibilities of freedom. However, it depends, of course, of our political system. Yeah.
I don't know if
Thank
Alexander
you.
wants to say something as final conclusion.
No. I appreciate very much the time, and thank you, Oscar, for organizing this. You're such a incredibly full of energy, and I'm deeply grateful to you for the opportunity to think this project through at its very early stages. There's much more to do, but I really appreciate having this platform to at least mull over some of these thoughts and to receive your feedback.
Okay, thank you very much. Thank you very much, Jedrzej.
Yeah, I think that, of course, I mentioned that I'm rather pessimistic. However, of course, we can find optimistic point of view because this is example our meeting here. It is possible to discuss in digital space about freedom of speech. From US via Spain to Poland, and I hope it will be possible in future. However, you know that unfortunately this battle for freedom of speech, this is a never-ending story, and unfortunately I'm sure that this is one of the main human rights, and battle with censorship, this is never-ending story, unfortunately.
Well, with this reflection, we finish here the international webinar, the first session. Thank you very much to the speakers. Thank you very much to the people who has attended the webinar, and see you on the 20 of July. The second session. And thank you very much to everyone. See you in the next time. See you the next session in the 20th.
Thank you very much, Alexander. Thank you very much, Oscar and David, Władysław. Thank you very much.
And thank you for the audience. Without the audience, we would have much less. So thank you very much for everybody who joined. Bye-bye.
Bye. Bye.